Hi everyone, this is Will and you're listening to Two Man Congress. So Chad and I were planning on doing a debate today, but unfortunately because of finals, Chad is unable to record for the next couple of weeks. That way he can actually focus on his schoolwork and get good grades, which is important. So totally supportive of him in doing that, and you're stuck with me for the next couple of weeks. So for these next couple of weeks, don't worry, I've got plenty of ideas and thoughts of what I want to do to be able to share with you. For this first one, though, I thought it would be useful to do a combination of all of the free speech topics that we have previously covered. So as you know, there have been 4 episodes about free speech that we have discussed so far, and what I want to do here is combine those into one, so that instead of having to go and look for them so that you get all the information needed, you can find it all in one place. So what you're about to hear is a combination and really a pre-recording of several episodes about free speech. And so in the first one, you're going to listen about what free speech is. The second, you're going to hear about where free speech is protected. The third is going to be discussing time, manner, and place, and what kind of restrictions are allowed to be put upon free speech in certain situations. And the fourth is going to be talking about free speech in schools. There are obviously other fields of free speech that we haven't talked about, such as corporate speech and what goes on there. And there are other topics too, which we will likely cover in the future, but those are more miscellaneous and not as relevant. Well, completely irrelevant, but not as openly debated as the topics that we have covered thus far. And so what we have covered thus far is a good overview of free speech and some of the most heated debates about free speech. And so we hope you enjoy this combination and find it useful to hear each topic back to back to back to back. All right, let's hop into it. What I want to talk about specifically is what kinds of speech is constitutionally protected speech. So in our last episode, we talked about some policy recommendations for social media censorship because of what had ended up happening. And those policy suggestions includes like a 3-part platform. And the first part of that is that social media should still remain protected from liability for what people say on their platform. So that provision would still stay the same. The second provision would change from the original to this, broken up into 2 parts. First, social media platforms would be protected from liability for censoring constitutionally unprotected speech, but third part would be unprotected from liability for censoring constitutionally protected speech. So we talked about the suggestions, but we never actually got down to the details about what is considered constitutionally protected speech and what is not. And so those are some things that we're going to talk about today. And there are 2 kinds of things that we need to know, is that certain kinds of speech are protected while others are not. And then where the speech takes place is an important detail. And so that's what we're going to be focusing on. Now, the First Amendment states that Congress shall make no law prohibiting the freedom of speech or the right to peaceably assemble and gather to petition their grievances. However, the Supreme Court has not interpreted no law to mean no law, meaning that there are certain kinds of speech that are most protected, there are certain kinds of speech that are somewhat protected, and there are certain kinds of speech that are not protected at all. And those kinds of speech that are protected are content-based material, so you can't discriminate against someone just because of their political viewpoints or because of their religious affiliation. For example, you can't just, if someone has a religious sign outside pointing times to when their religious services are. You can't make a rule specifically targeting those signs. What you would have to do is create a law that is content neutral, and these are somewhat protected. Content neutral laws are regulations that apply to everybody, regardless of their association. For instance, solicitation laws or permits for parks and things like that are considered content neutral regulations, as long as they don't discriminate against a certain group or organization. And those kind of regulations are somewhat protected. Now, what kind of speech is not protected is things like obscene material, libel, or criminal speech. And when I say criminal speech, I mean things like perjury, conspiracy, or inciting violence. And those things have not been considered protected speech by the Supreme Court. Now that we've talked a little bit about what kinds of speech are currently protected, let's just go into a bit of the history and talk about how we got to where we're at. So in Schneck versus the United States, the Supreme Court introduces something called the clear and present danger test. In Schneck, it was a time about the war, during a war. This was 1917, I believe, is when the opinion was handed down. But Schneck was going around and passing out pamphlets that encouraged people to revolt against the government during this time. And the Supreme Court didn't like this because it presented a clear and present danger to the United States government in the middle of a foreign conflict. Now, the court kind of moved away from this test and went to a bad tendency test versus Gitlow. Well, in Gitlow versus New York. And the bad tendency test in Gitlow, he was a communist, and this was during the Red Scare, and he was one of the leaders. What happened here is that even though he wasn't presenting a clear and present danger, his tendency of what he was sending might result in a clear and present danger, and that's what a bad tendency is. So the justices in this gave this example that his content was a spark that, if nourished long enough, could turn into a flame, a fire that could engulf and present a clear and present danger for the United States. And so that test was often used. But in Caroline Products versus the United States, in footnote number 4, and it's probably one of the most famous footnotes out there for constitutional law, it's something called the preferred freedoms. And so what that means is there are several preferred freedoms that are mentioned in the Bill of Rights. And those preferred freedoms require a lot of protection. And so any law that infringes on those freedoms needs to be scrutinized heavily. And so what this is, it's called strict scrutiny. And any law that is passed needs to have a high government interest, a very strong one. And any regulations must be narrowly tailored, meaning that it has a very little effect on infringing rights outside of the one that is trying to narrowly tailor. And there are tons of examples where the United States has a high interest. They have a high interest to prevent violence. They have a high interest to prevent property damage, criminal speech, encroaching on the right of others, burdening government functions, and trespass. And that's just kind of a general list of things that they have a high interest in restricting so that people can speak freely without breaking those kind of things. All right, so now that we've discussed the history and what kind of speech is most protected, we're going to talk about a couple of examples of speech that has been deemed protected speech or speech that has not been deemed protected speech. And for these examples, we want to discuss symbolic speech and then ensuring order. So there are two cases that we're going to discuss briefly for symbolic speech. That is United States versus O'Brien and Texas v. Johnson. So in United States v. O'Brien, David O'Brien took his draft card in 1966 and he burned it in front of the Boston courthouse. There was a hostile crowd that gathered, and the FBI took them to question them. In this questioning, they said that they violated the 1948 Selective Service Act and by burning the draft cards, and said that that was illegal. They were arrested, and O'Brien said that this freedom of expression, even though he wasn't necessarily speaking, this expression was considered protected First Amendment speech. So this went to the Supreme Court, and they discussed it, and here is what they had to say. In conclusion, we find that because of the government's substantial interest in assuring the continuing availability of issued selective service certificates, because amended B is an appropriately narrow means of protecting this interest and condemns only the independent, non-communicative impact of conduct within its reach, and because the non-communicative impact of O'Brien's act of burning his registration certificate frustrated the government's interest, a sufficient governmental interest has been shown to justify O'Brien's conviction. In other words, the Supreme Court upheld the conviction because the United States had a strong interest in maintaining the Selective Service Act, and the Selective Service Act just allows people it makes it legal for the United States to draft people. So they had a strong interest in upholding that act, and O'Brien's actions went against that interest. Also, the Supreme Court said that that interest was narrowly tailored to where it only protected the Selective Service Act and nothing else. So, the Supreme Court held that this symbolic speech was not okay because of the governmental interest. However, in Texas versus Johnson, this is a case about the burning of the American flag. And Johnson said that this was his protected speech because it was symbolic. It didn't cause any harm. It didn't hurt anybody. And in Texas, it said that it violated their law. So this case went to the Supreme Court, and ultimately what ended up happening is because there was no harm or impact on the people, the burning of the American flag in this instance was all right. The Congress did not like that, obviously, and they created a law to overturn Johnson. However, that law was also brought to court and was found unconstitutional as well. So, burning the American flag in certain ways was found justifiable. Now, the second example that we want to talk about is ensuring order, the preservation of order. And in Chaplinsky versus New Hampshire, there was a Jehovah's Witness named Walter Chaplinsky, and he was selling religious pamphlets to a large crowd that had gathered outside of a building. And this crowd became very hostile, and he was very hostile to the crowd, and ultimately the authorities came and to try and prevent any more hostility, arrested Chaplinsky, who complained and that his right to speech was prohibited because of his expression, and he complained that people who were going against him should be the ones arrested, not him. In this instance, the Supreme Court held that his conviction was justified because he was using something called fighting words, and he was causing harm and inciting violence with these fighting words. What they say is the court agreed with this fighting doctrine that the government may regulate words directed at another individual which by their very utterance inflict injury or tend to incite immediate breach of peace. So those are just a couple of examples of constitutional cases mentioned by the court that show what kind of speech is most protected, what kind of speech is somewhat protected, and what kind of speech is not protected. This has been a major issue ever since speech has become more and more popular, and lots of, including the civil rights movement, any other movements, Donald Trump's election, and all these things that you could even say January 6th, where speech has been brought into question a lot, and it's been brought into question a lot more and more recently. It was nearly 100 years before the first case was brought before the Supreme Court regarding speech, but now there have been many courts, including schools and locations, and what kind of speech is harmful and what kind of speech is not. So those are a lot of the Supreme Court cases and the way that they've interpreted what kind of speech is constitutionally protected and what kind of speech is not protected. So now let's discuss some of the implications and what this means for you. Well, obviously, the first thing to know is that this information is important because it's interesting. You could just use this information to your knowledge to know what kinds of court cases have been considered constitutionally protected speech and what ones have not been considered constitutionally protected speech. The other important reason for bringing this up is because it helps to refine the policy suggestions. Because the courts have developed such a vast method of interpreting these cases, we have a lot of knowledge about what is protected and what is not. So, a good way to just phrase the policy suggestions that we made in social media censorship is to just say that it's bound by the Constitution. It's a simple way of doing it, but ultimately what it's going to do is that those that are unconstitutional speech would be censored on social media, while those that are constitutionally protected speech would not remain censored on social media. And social media companies can be held liable for those things. So it just helps to know that this information is already out there and it is relevant, and you don't need to recreate all of this information to alter the current law and policy. Perfect. So let's hop right into things. What I want to talk about today is kind of an extension of what I did during the first solo episode, which was the freedom of speech. But this time we're going to be focusing on location, because that is the first thing that the Supreme Court looks at when determining whether or not what kind of level of protection speech should get. Just as a review of what we talked about in episode 2, which is what constitutes free speech, there are three kinds of hierarchy of protected speech. There's most protected, somewhat protected, and least protected. The most protected are content-based speech, meaning regulations can't go against a specific religion or a specific standpoint. There's somewhat protected speech, which is content neutral, meaning that regulations can be made regarding permits that don't target a specific standpoint. And then there are least protected, which obviously these are obscene material, criminal speech, such as perjury or libel. So just like there is a hierarchy of protected speech, there is actually a hierarchy of protected places where that speech can take place. In other words, speech may typically be considered free speech, may not be considered free speech in a certain location. And so let's just look at those a little bit. There are 4 places. The first one is a traditional public forum. Second is a designated public forum. Third is a limited public forum. And the fourth is a non-public forum. Looking into each of these a little closer, traditional public forums are parks or streets or sidewalks where anyone can just bump into anyone and exchange their political views without any fear of government regulations. Now, designated public forums are areas such as city auditoriums or public meeting rooms where it's necessary to have restrictions. This could also include large event gatherings at a park that require a permit. And it's necessary because you got to maintain the numbers to make sure that things stay under control and nothing goes wrong. Now, a limited public forum are places that the government has opened up for a specific purpose. These are like state universities where the specific purpose is for an education. So, for example, a university could put up a website and they could regulate any of the comments that are criticizing a university coach, because that's not related to the purpose of the website. So that's an example of a limited public forum. And a non-public forum is a category that encompasses government facilities that have not traditionally been used for public discourse, and then private property where the owner has not given consent for public discourse. As far as the government facilities and that includes jails and defense plants, nuclear facilities, and so on. And then the private property, that also includes private forums such as social media and private universities. All of these forums receive a different level of protection. The public forums, the traditional public forums, receive the highest protection, so on and down the list to designated public forums, limited public forums, and non-public forums. Non-public forums receiving the least protection if an issue was to rise with the constitutionality of a regulation regarding the First Amendment protection of free speech. So now that we've talked about some of the locations, let's just give an example where this was taken into place. And in this case, we're going to talk about McCullen versus Coakley, which was decided in 2014. But before we do that, I just want to say, obviously, the Supreme Court went into a whole lot of analysis regarding the location, and then what kind of tests that they were going to use, and then what kind of speech was being protected. Instead of focusing on all that analysis to make the decision, we're just going to focus on the first step, which is the location, and we'll state that, and then at the end we'll just say what the Supreme Court ended up deciding about the case, because obviously it went into the next steps as well. Alrighty, let's hop right into this case. So McCullen versus Coakley, the way that we're going to do this is we're going to talk about what regulation was being contested and why it was being contested. We're going to talk about who McCullen was quite thoroughly, and we'll briefly talk about Coakley because, obviously that's the other party of the case. And then we're going to focus on the location, and then we're going to focus on the decision. Okay, so McCullen versus Coakley. First, in 2007, Massachusetts amended its Reproductive Health Care Facilities Act, and this was an act that had been enacted in 2000 to deal with clashes between abortion advocates and pro-life advocates. And so this amendment, what it did is it made it a crime to knowingly stand on a public way or sidewalk within 35 feet of the entrance or driveway to any reproductive health care facility. And the original version of this only created a 6-foot no approach zone within the facility. And so what this did is it expanded that really far. And McCullen was a 76-year-old grandmother who engaged in pro-life sidewalk counseling. So sidewalk counseling, instead of carrying a sign or shouting at people their beliefs, was a method of trying to dissuade people from receiving an abortion by offering literature and by offering alternative solutions other than an abortion. Because of this amendment, she felt it made it really hard for her to practice this, and so she sued the Attorney General, which was Martha Coakley, and claiming that this law violated her First Amendment right, and what she wanted the Supreme Court to do was to keep the state from enforcing it. So first, this went to the district court, which upheld the law, and then the Court of Appeals upheld the law. And so McCullen took it to the Supreme Court to decide whether or not this law was constitutional. So let's hop right into the location of this. Where was she doing a lot of this stuff? Well, the law talks about obstructing while knowingly standing on a public way or sidewalk. And that's where McCullen was doing most of her counseling, was on the sidewalk. And so she felt like this really limited her space, considering how this was a traditionally public forum. And the Supreme Court agreed with her in this context, was that this was a traditionally public forum, because the sidewalks are to be expected as the place where you can engage in conversation, where you're going to bump into somebody and you can just talk. Now, it makes sense that this barrier would prevent people from holding signs or obstructing the place from it continually. But what McCullen was doing was walking with the person from a considerable distance to the abortion clinic as she tried to dissuade them from receiving an abortion. So having passed the first step, the Supreme Court decided to continue to examine the case because of this public forum. This case received strict scrutiny, meaning that the law had to pass a high test in order to be considered a constitutional law. And so now they get into the speech and they talk about whether or not it's narrowly tailored, whether or not this is content neutral law, which ultimately they did decide that it was a content neutral law, but because it wasn't narrowly tailored, meaning they hadn't really tried any other alternatives, it was an unconstitutional law. So the Supreme Court said that this law was unconstitutional. So why is this case important, and what implications does it have for you? Well, if you remember all the way back to our first debate, we talked about social media censorship and whether or not social media should have to abide by the First Amendment. In that debate, or rather at the end of that debate, we suggested a policy that would hold social media platforms accountable for anything that wasn't constitutionally, for speech that was constitutionally protected. So social media platforms would still have the right to be able to censor material that was unconstitutional, but they would also be held liable if speech that was considered constitutional was censored by the social media platforms. And so the reason why this is important, why I'm bringing that up, is because location is the prime part, why the prime challenge to the constitutionality of a law, of a policy that was like that, if it were to be passed. Because if it were to be passed, then undoubtedly the social media platforms would go to the Supreme Court saying, hey, they can't do this because, we're a private platform. And private platforms have a lot of authority, or rather speech on private platforms aren't heavily protected because of the private organization. And so what would end up having to happen is that law would be challenged, saying, is this a compelling governmental interest? And is this narrowly tailored to where it doesn't infringe on the right of the private organization? So that the conflict here of free speech is resolved in a meaningful way. So that's where location really comes into play with this argument. But we don't really know what's going to happen or what the Supreme Court would say until that were to happen. And so that's where you come in. You would take this to your legislature and you would talk about getting this passed so that it can be taken care of, and the Supreme Court would eventually hear it, and we would say, okay, yes or no, this is unconstitutional, or that yes, this is constitutional, and the Supreme and social media platforms would have to abide by that. And that's the difficulty of politics and the simplicity of politics. Politics is very simple. You as a constituent have an idea. You take it to your legislature. The legislature proposes it to Congress, and then it goes to Congress and the Senate and the president, et cetera, until it either becomes a law or doesn't become a law. If it becomes a law, what happens then is, often a party is going to is going to challenge the constitutionality of that law, and then it's going to go to the Supreme Court, and the Supreme Court says, yes, this law is constitutional, or no, this law is unconstitutional. And that's all politics is. It's super simple. But yet we complicate it so much because of these party ideologies and identities, and we make it so hard to get things done because of all these differences of opinion that we have. But it doesn't start if you don't do something. So you have to do something, and that's what we're encouraging you to do, is actually take action. I mean, this policy might not even be a very good policy, but we don't know if we don't actually try. So that's something that we would encourage you to do, is if you like the policy suggestion, or if you like any other policy suggestion, just take it. Take it to the legislature. See what they think. And vote on people who you think might vote for it. And that's how politics works. And that's all it needs to be. And that's how you fit into this situation. One of the things that I've been doing in these Patreon ads is sharing how great it would be to be a patron. We have those 3 tiers, and we're excited for things that we post on those tiers, and how people can be actively engaged. But I haven't really said thank you to those who support us and listen to us. And so that's something that I want to do now. Just thanks. Thanks for all that you do. Thanks for your feedback, and thanks for your guidance, and all the helpful comments that you give us to help us to improve. It's useful, and we appreciate every single bit of it. For those who are just new or want to support us in any way that you can find us on Patreon and give us some support there. If you like what we're saying, if you like what we're sharing, then this support helps us to know that. It's a great community. It's a great way for you to become involved. And so you can go to patreon.com/2mancongress, and 2Man Congress is spelled out TWOMANCONGRESS. And go ahead, join a tier, and support us in any way that you can, and we'll be happy to contribute in any other way that we can. We're going to continue our discussion on freedom of speech. The last 2 solo episodes I've talked on, I've focused on the freedom of speech. In the first one, I talked about the kind of content that receives the most protection. And in the second episode regarding freedom of speech, I talked about the location that receives certain kinds of protection. Well, today, I'm actually going to focus on what the government can do. So before I was talking about what speech is protected, and this time I'm going to be focusing on what kind of restrictions the government can put into place. And a lot of this is actually going to be some review, because we talked about some of the restrictions that the government can put into place when we talked about location, and we talked about some of the restrictions that the government can put in place when we talked about content. But we're going to review all that anyways, and we're going to go into time, manner, and place, which are the kinds of restrictions that the government can do as long as they fall within those time, manner, place, or TMP guidelines. Okay, so that's what we're going to focus on. As a bit of a review for the kind of content that receives the most protection, you have content-based speech, you have content-neutral speech, and then you have obscene material or criminal speech or libel. And obviously, those kinds of regulations that try and restrict content-based speech receive a high level of scrutiny, meaning those restrictions are not likely to pass through the court system at all and to be found constitutional. Content-neutral restrictions are a lot more lenient, however, because they don't target one group or another. And then obscene material, obviously free speech does not really apply in these situations because it's harmful, offensive, and could be quite damaging to those who consume that type of material. So let's talk a little bit about the locations. And you have 4 traditional forums, 4 kinds of forums. The first one is a traditional public forum. The second is a designated public forum. Then you have a limited public forum, and you have a non-public forum. So those kind of examples of those, a traditional public forum, are parks and sidewalks. Designated public forums are city auditoriums or buildings like a library. A limited public forum are places where the speech is kind of determined. For example, a school where the forum is designed to provide an education. And then non-public or private forums, non-public governmental agencies such as jails, and then private organizations such as personal businesses or platforms. So that's a little bit of review of what kind of speech is protected in both the locations and the content. If you remember from the last episode, we talked about how the location is the first thing that the Supreme Court justices really look at when they're examining the restrictions that the city or the state or the federal government tried to use when they imposed a law. And that is true, but ultimately a lot of these time, manner, and place restrictions are going to be super intertwined, meaning we're going to examine time, manner, and place as a whole instead of independent from location or content, because it examines it as a whole. So, for example, time, say you have a permit to a park and the park closes at 11:30 p.m. and that's when your permit expires. That is an example of a time restriction that the government has a right to enforce because they want to make sure that you're not trespassing or causing damage to public property in the middle of the night. Manner makes sure that the content that you're using, well, that the restrictions that are out there are content neutral. So this makes sure that a permit to a park does not discriminate against one organization over another. It makes sure that a religious group just has much of an opportunity to use the park as a political group, and so on and so forth. Place actually talks about the place, and that's going to be the traditional public forum or non-public forum, and certain restrictions can be enforced depending on where the place or where the event is taking place. So, for example, a park at a certain time with a certain permit, as long as it is non-discriminatory based off of the content and reasonable within the time, may be seen as a reasonable restriction on free speech. So if that all makes sense, you can see how so much of it is intertwined, where the place affects the manner and the time affects the place, and they're all so intertwined that even though I've been talking about it as if they're exclusive from each other, they are, well, one and the same, where you have to examine it holistically. So now what I'm going to do is I want to give an example of where time, manner, and place restrictions may be seen as justified. And the way that I'm going to do this, I'm going to share a hypothetical from one of my constitutional law classes that I took when I was in my undergraduate to share an analysis of how this may be seen. This is a hypothetical case. So there is no actual answer that has been given provided this case, and it's not a real situation. But we will be using real cases in providing our analysis. So that's something to look forward to. Is we will talk about Schempp or Texas v. Johnson or McClellan versus Coakley to determine whether or not these restrictions are constitutional. With that said, let's discuss this hypothetical case. So in Oregon in 2003, during the war in Iraq, there was a group of college students who were very unhappy with how the war was going, and they decided to gather in a public park at a certain time and to protest all day and into the evening. Now, this particular park required that a permit be obtained so that you can protest during that specific time. And all permits were to expire by 11:30 p.m. and the protesters were to vacate the park at that time. However, the college students, they gathered together to protest, and they marched all day, and they marched into the night, and they chanted, and they held up banners, and they had some symbolic barrels full of oil so that they could express their distaste with how the government was handling the war in Iraq. And 11:30 came and went, and the police arrived and told them to vacate the premises, and they refused, and they continued to march until midnight. And then at that point, the leader stood up on a podium, shouted some things that may be harmful for the U.S. government to hear. Nothing too crazy, just condemning the actions. And then he kicked over the barrels of oil, which were just colored water filled with dye, which then stained several of the trees, the grass, and several park benches and tables. So the police took him, the leader, and several others into questioning, and the leader then demanded or argued that his First Amendment rights were violated because of his arrest. So what do you think? Do you think his amendment rights were violated, or do you think these are proper time, manner, and place restrictions and that were provided by the city? Well, if we remember from McCullen versus Coakley, and that traditionally public forums such as sidewalks or parks receive a high level of scrutinization. So we need to look at the location here to see how much protection of free speech this location receives. And we see here that time actually plays an important role, because at 11:30, this traditionally public forum actually becomes a protected, limited public forum, in the sense where some restrictions may be in place to protect the property, just like you may have some restrictions at a national park to protect the national parks. And so the leader in this case ended up violating the time and ultimately the location of this usually traditionally public forum. Okay, so let's talk about the content that was being given. Was there any discrimination against this leader's content or what he was saying about the war? And the answer would be no. All organizations were given the exact same opportunity to gather. If they had a large gathering, they needed to have a permit. No organization was restricted in that sense. All organizations had to leave the premises by 11:30. And so having this restriction based off of manner was not a violation based off of content, because it was a content neutral restriction. Okay, and we had already talked about time, but we had already talked about, and so let's talk about the expression that was given. In Texas versus Johnson, we discussed the flag burning and whether or not flag burning was a symbolic form of speech that was protected. And in that case, the Supreme Court said, yes, it was. But the reason why it was protected is because it wasn't harming other things or the property that the expression was being conducted on. And the same thing with Shemp. The reason why that was a violation is because it happened on governmental premises. But in Texas v. Johnson, that was a constitutional form of expression. But here, in this case, we see that the oil actually caused a lot of damage. The colored water caused a lot of damage to trees, the grass, and, well, just the park in general. And so the cops, in this case, there is a very justifiable reason for why he was taken into arrest and why this wouldn't have been a violation of his First Amendment rights. Like I said in the beginning, this is a hypothetical case. There is no right or wrong answer. The reason why I'm sharing this is to see how time, manner, and place restrictions can actually play a role in how these cases can be considered constitutional. So what does all of this mean for you, this hypothetical case and this information about time, manner, and place and what kind of speech is protected and what kind of speech is not protected? Well, it's all important because you need to know what you can and can't say and where you can and can't say those kinds of things. Ultimately, what we learn from all of this information is that free speech is not always free speech. There are times when the government can and will put restrictions on free speech, and it's completely seen as constitutional, because you can't just be expected to run around somebody's house or somebody's company screaming things, swearing at the top of their lungs, because you can't just allow everything like that. It becomes harmful and unhelpful. So there are times when the government can put these restrictions on. The important thing to realize is that free speech is still heavily, heavily protected. If you're in a traditionally public forum, like a park or in a sidewalk, the Supreme Court has shot down many regulations concerning regulating the freedom of speech. So it's important to know this information, because you can protest things that you don't like in a constitutional way, and you can protest things you don't like in an unconstitutional way. So it's important to know which ways are constitutional and which ways are not constitutional, in which ways the government can constitutionally regulate that speech, in which ways the government can unconstitutionally regulate that speech. And if those things are taken into account, you can petition in a very successful way without having to worry about being arrested or breaking the law, but still getting your voice out there and ensuring that proper change can be made. Today's topic, we're going to be continuing a discussion on free speech, and today we're actually going to be discussing some stuff that are a little more controversial, because we're going to be talking about free speech in the classroom. And as current events tell us, there have been some recent developments where the freedom of speech in the classroom is a heavily debated constitutional topic. We won't go into any of the debates today, but we want to give a little bit of analysis, and we'll give an introduction to why the debates are actually being debated. So here's what we're going to do today. We're going to talk about the freedom of the speech, the students. We're going to talk about freedom of speech for the teachers, and we're going to discuss a little more about those challenging topics that could potentially be brought to the Supreme Court, and will actually most definitely be challenged and brought to the Supreme Court. But let's go ahead and discuss student free speech. We want to give a little bit of a refresher on some of the forums that we discussed in our previous episodes about free speech, because if you remember, we've talked about what speech is protected, we've talked about where speech is protected, and we've also talked about time, manner, and place, which are how the kind of restrictions that can be put on free speech if they meet constitutional requirements. The school is a limited public forum, which means that the government has some say on what speech can and what speech can't be presented. But there's been a lot of debate, because this is the freedom of speech, about what kind of speech actually is protected. This debate was first brought up in Tinker v. Des Moines, and there were a lot of adults and some students who decided to fast between December 16th and New Year's Day to protest the Vietnam War. In between those two fasts, they were going to wear black armbands to symbolize their protest, dissenting from the Vietnam War. The school, however, thought that this protest might be a little disruptive, and so they sent out a notice to let everybody know if they showed up wearing armbands that they would be suspended. So everybody except for a few people followed the notice and did not wear an armband, but a few people, including the Tinkers, wore an armband to school and they were suspended. They sued because they felt their First Amendment rights were being violated, and they ended up winning. There are a couple of things that we learned from this case that are important for our discussion. The first thing is that as long as speech does not interrupt the educational process, the government has no authority to prescribe what speech can and cannot be protected. in schools. So the armbands were not being disruptive in the classrooms. It did not distract from the content that the teachers were trying to teach. And so the armbands were considered a protected form of First Amendment expression. The other thing to note is that even though schools are a limited public forum, freedom of speech is still heavily protected in the schools because you cannot be expected to just walk in and check all of your constitutional rights at the school gate, which is a term that is used in Tinker v. Des Moines. So Tinker v. Des Moines is the first big case that we have about the freedom of speech in schools. The second big case that we have about free speech in schools is school district number 403 versus Frazier. In this case, there's a student. He was asked to give a speech at the school. And in his speech, he used a lot of obscene and profane language. And while the school was not impressed, obviously, and decided to take some disciplinary action against the student, against Frazier, because of the content that was in his speech. And the school district won in this case, saying that the free speech was not protected. So there's a couple of things that we learn from this case in Frazier. The first thing is that the schools can restrict some free speech, and so although it seems in direct opposition to Tinker, what it really shows is there are forms of free speech that can be limited, and that Tinker was not an absolute case where every form of free speech brought by the student is going to be protected speech. The third and final case that we want to talk about student free speech is Morris v. Frederick. And so this case, what happened is the Olympics were going on in Juneau, Alaska, and there's going to be a parade coming through, and the principal thought it would be a good idea for everybody in the school to get out and to watch the parade. And the school participated in events in the parade, and students were lined up across the street from the school and on the school premises to watch this event. As the cameras came by, there was a student, Frederick. Principal Morse was the principal. Those are the two parties. Morse was the principal. Frederick was the student. He held up a banner that appeared to promote the use of illegal drugs. And so the principal walked over and demanded that the banner should be taken down. And, of course, the student was a little upset and took his case to the Supreme Court. At first, the district court agreed with Morse that the banner should be taken down, and then it was reversed by the circuit court, and then at the Supreme Court, the court agreed with Morse that the sign should be taken down. But here's the interesting reason why. It says that there was the substantial disruption analysis that is used in Tinker should not be applied in this case, but instead we should address the health and the safety of the children via the promotion of illegal drugs. And so, because the school has an interest in protecting the children and has stated that one of their goals was to limit the use of illegal drugs, and this banner was found not to be used as offensive, but rather to fulfill the purpose of the state interest of limiting drug use. And because it was at a school-sponsored event, it can be inferred, if this was approved, that the school district is fine with the use of illegal drugs. And that was not the message that they were trying to send. So free speech can be limited in that way too. So from these three cases, there are a few takeaways. First of all, from Tinker, we learn that free speech is allowed if it is not disruptive in the classroom. We also learn from School District 403 v. Frazier that free speech is limited, of course, for obscene material and profane content. We also learn that free speech is limited for content that has been deemed harmful for the kids attending school. The last takeaway is that free speech is allowed for content that may be considered offensive, as long as that content produces no proven harm. So that's the students. Let's talk about the teachers. There's really been no cases that where teachers have challenged the constitutionality of their free speech in the classroom. However, there is a case, Garcetti v. Cibolos, excuse me, on the pronunciation of that name. But in this case, there was a government official, and to note, teachers are government officials, so this applies to teachers as well. But there was a government official who wrote an affidavit as part of his job and submitted the affidavit to a court, but the affidavit wasn't included in the court case, and he felt that it was out of spite, and so he challenged, saying that his constitutional rights were violated, that his affidavit should be included. However, he lost this challenge, or rather, the Supreme Court held that the speech taken by government officials in the course of their work is not protected speech. So if the court wants to exclude a certain thing, then they can exclude a certain thing. But in the case of teachers, what this means is teachers should be teaching what their subject is, and they should not be branching out into other subjects. But the biggest takeaway is that teachers have a limited amount of free speech in education, and likely their rights will be similar to the rights of the students. Okay, so let's get into some of the more challenging issues, or rather the more controversial issues with regard to current events and what is being taught in schools. There's been a lot of controversy about what can be taught in Florida. Florida is being challenged heavily in this regard, and it's because of HB 1557, which is the Parental Rights in Education. And just as a standard, I don't want to use the nicknames of bills just because I feel like those can be inaccurate or potentially misleading, and so I'll just go with what the names of the bills are, of what they are given. Of course, governments can give misleading names for bills as well, but that's going to be a standard that I use regardless of what bill is being discussed. Okay, so with this bill, I want to give an overview of what the bill is, and I'm going to give a direct quote of what Florida says this bill is, and then I'm going to read the contested text rather than just discussing the contested text. That way you actually have an idea for yourself of what the bill is, and this is direct. Okay, so the overview of the bill as given by Florida requires district school boards to adopt procedures that comport with certain provisions of law for notifying student parents of specified information. It requires such procedures to reinforce fundamental right to parents to make decisions regarding upbringing and control of their children, prohibits school district from adopting procedures or student support forms that prohibit school district personnel from notifying parents about specified information, or that encouraging students to withhold from parents such information, prohibits school district personnel from discouraging or prohibiting parental notification and involvement in critical decisions affecting students' mental, emotional, or physical well-being, prohibits classroom discussion about sexual orientation or gender identity in certain grade levels, requires school districts to notify parents of healthcare services, authorizes parents to bring action against a school district to obtain declaratory judgment, provides for additional award of injunctive relief, damages, and reasonable attorney fees and court costs to certain parents. So that's the overview of the bill. I think it's pretty straightforward. Pretty much just says that parents are to be notified of any health or mental choices that the children are going to make at school. The contested text of the bill is in regard to the sexual orientation part, because it goes directly about what teachers can and cannot teach in the classroom. But it's part 3. Classroom instruction by school personnel or third parties on sexual orientation or gender identity may not occur in kindergarten through grade 3 or in a manner that is not age appropriate or developmentally appropriate for students in accordance with state standards. So this is the challenge that I've heard most of the bill, and it's one about freedom of speech, because a lot of what I've heard is how can Republicans be all for freedom of speech, and then they go and introduce a bill that limits the freedom of speech. Well, there are a couple of questions that need to be answered, and I'll do this as an analysis to present the questions, but I won't actually do the analysis because the analysis hasn't been done before the Supreme Court, and although I can give permissions, it's not really my place to determine what the Supreme Court should or should not say about a bill. So, what the Supreme Court would do in the case of this bill, and given some information, first, they would determine what kind of forum this is. And this is straightforward. It's a school setting, and there's no contest to whether or not it would be a school setting. So it would be a limited public forum. And that is just a fact, and so there would be no contest there. What would be contested, and what I will not give my opinion to as far as this content goes, but what would be contested is the manner of speech that is being limited. And is it being limited because it is offensive, or is it being limited because of the potential harm for kids? That's going to be the big question. And then the third question, or the third part of the analysis that will happen is the speech that is barred being harmful for kids? Those are going to be the 3 biggest points. What's the manner of speech? Is it limited because it's offensive or because of its potential harm? And is the speech actually harmful? So that's going to be the biggest questions when this case goes to the Supreme Court. It is going to be challenging enough to where it goes to the Supreme Court. The other big case in current events that are going on is the banning of books in Texas. And these same questions are going to be asked. Determine the forum. It's a limited public forum, which means that there are some restrictions that the state can put on schools. They're going to have to ask, what manner of speech is being limited? Is it being limited because it's offensive or because of its potential harm? And is the barred speech harmful for kids? So those questions are going to be asked. And there's the case for both sides. The biggest question is going to be proving the harm for kids. If those books, or if the content is proved harmful for kids, then the speech will most likely continue to be barred. Also, the speech can be accessed in other forums. For example, with the book banning, the books may be banned in schools, but they're not banned from public libraries, and so the content is still available out there. But there's a whole bunch of questions that the Supreme Court is going to have to answer in regard to these, and the takeaway for you is, what kind of content do you want your kids to have? Do you agree with these laws that are currently being passed, or do you disagree, and why? And what will you do about it? Would you have your kids in these schools? Would you not have your kids in these schools? Or would you have your kids in schools that have opposite laws, and vice versa? And that's why this is such a big issue for parents and teachers and so many others, just because of how close to home these are, because kids are as close to home as it gets. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.